And Colonel, we were talking about mortgage foreclosures before we took a break, and now we're back to it.
Yes, sir.
And let's talk about this, that in a mortgage foreclosure defense, let's imagine that the client has retained you. You have put up a defense.
Yes, sir.
That mortgage foreclosure we know takes months and months and months and months.
That's correct.
We know that at least here in the 9th Judicial Circuit, the judges now order that before they will hear a mortgage foreclosure case, they must, the lender must first agree to a mediation with you and the client, right?
That's correct. And residential foreclosure, that's correct.
And so at that mediation meeting would be you, your client, the homeowner,
right,
would be the plaintiff's attorney.
Correct.
And then a representative of the lender.
Right. They're usually by phone, but they're required to be there by phone anyway. Okay.
So here you are at this meeting. What is the plaintiff and the lender, what do you think that their thoughts are as far as what they are obligated to try and accomplish that day if it does get accomplished?
Well, that is really the opportunity, I think, to really make the deal or make an agreement in reference to modifying your mortgage. It's been my experience that the lender is usually there or appears to be there with the idea of honestly reviewing the financial information and other documentation that your client has to have presented prior to the mediation. Then they take that information, income, expense, etc., put it through a formula that I don't know the formula, but they put it through a formula, and then they tell you whether or not your client qualifies for the HAMP program, the Home Affordable Modification Program, which is the government-sponsored thing where you deal off 31% of your gross income as your mortgage payment, or whether or not you are qualified for one of what they call in-house programs, where they would agree to modify your loan in some way based on the financial information you've given them. And so it's been my experience that usually, in my opinion, it seems to be an honest, straightforward deal where they truly are concerned and try to work something out. I've been to, notice I said usually, because I have been to some where they just said, nope, I'm sorry, you don't qualify for anything, and that's it. And, that happens in the first 5 minutes of the mediation. So it's pretty obvious to me that they are not being fair and honest at that stage of the game, but that's sometimes that happens.
And so prior to this meeting, your client has filled out, I guess, what I would call a financial affidavit.
Basically, kind of a rough one, but still they filled out a financial affidavit. They've supplied copies of bank statements for a couple of months. They've supplied paycheck stubs. Had an incident yesterday. The paycheck stub didn't look, it was just a check. And not the formal-looking thing that oftentimes you think of as paycheck stub that shows gross pay to year and gross pay this time and all the deductions. It's just a check. And the mortgage company would not accept that, even though it was, in fact, his paycheck. But anyway, they get back to the point. Your paycheck stubs, you've got the financial affidavit. You've got one thing they always want is a copy of your electrical statement, your last payment. That's to prove that you have the electricity on and that you still live there. And so that's the information they take, and that's really about it. They look at and decide. You also usually have to have a hardship letter.